So thanks for coming, everyone. This is the Seattle Angel Conference Workshop Series. We try to help entrepreneurs make progress with their startup journey, especially when they're thinking about the outside fundraising process. And we try to help people who are accredited learn how to write their first check. And so we carry that forward. So we have a bunch of people here who are entrepreneurs. We have a bunch of people here that are investors, and part of our goal is get everyone to know each other. And so one of the ways we do that is through introductions.
All right, so just to give you a little bit of background on Hughes Media Law Group, we're a boutique firm here in Seattle. We help early and mid-sized companies with outside general counsel services. So we really run the gamut of what you might need for getting your startup up and running. I spent the last 3 years before joining Hughes Media Law Group at Dorsey & Whitney, helping private and public companies raise capital. So securities law exemptions are sadly one of my favorite topics. I find them very interesting. As you go through the fundraising process, you might disagree with me given some of the hurdles you have to jump through. So in order to kind of get through the exemptions, I thought it would be good to just start with some basic foundational information about what we're going to be talking about, so things maybe fall into context. So first of all, what is a security? What are we trying to get an exemption for? So we all probably know the very common types of security is going to be stock, but it could be any kind of equity, including LLC membership interests, partnership interests, any sort of equity you have. It also includes any instrument that's convertible into equity. So that includes convertible notes, safes, warrants, stock options. All of that also has to comply with the securities laws. If I was giving this presentation to a group of attorneys, I would probably get more into this investment contracts note here on the slide, which is the test that the SEC uses to decide if what you're selling is in fact a security. It's what they use to decide whether coin offerings fell into their purview, and not really going to be something you have to worry too much about here. Most early stage companies are selling equity, convertible debt, issuing safes, and stock options. So those are going to be kind of our big picture throughout this presentation. I just wanted to provide you kind of a list of what types of laws might apply and to show you the breadth of what we're trying to avoid applying. So the biggest one that's going to come into play is the Securities Act of 1933. So it's been around quite a long time. And then the simultaneous corresponding state securities laws. So in the realm of securities regulation, you have both the federal government regulating sale of securities and each state. And you'll see as we go through, there'll be some things we look at, only the federal government's rules apply, and in others you have to comply both on the federal level and on the state level. So we want to avoid having all of the regulations that are under these laws apply. We just want to really minimize it when you're at this early stage. It's very expensive to pay for compliance, to make sure that you're staying within the bounds of these laws. And so we're going to give you the tools so that you can structure your offerings and get through this with a pretty minimal compliance. So when do these securities laws apply? What I found a number of entrepreneurs don't realize is that the security laws apply both to an offer and to the sale. So simply making the offer to somebody that you want to sell them a security could in fact trigger the compliance requirements. And so you want to make sure your ducks are lined up before you start telling people that you're selling some sort of security. And again, this is all to avoid the registration process. So if we don't have an exemption that applies, then you would need to be registered, the security itself would need to be registered. And what that means is think of your IPO. You go through, see a full registration statement, full-blown prospectus. It's a $1 million plus adventure in legal fees, accountant fees, underwriter fees, We don't want that. That's not where you guys are at this point. We're really just starting the beginning stages of fundraising. But if you don't comply with the way the exemptions work, the alternative is you have to be registered. So again, this is going to be a very technical talk today. So please interrupt, ask questions as we go. I think I can trying to get the chat up, but I'm not able to see it. So John, if you see something that we should talk about as I go through, just feel free to jump in and stop me because I can't seem to see.
Yeah, mostly the chat is me posting questions in there that we'll get back to later.
Okay, perfect.
Although other people who have questions should be posting them into the chat, and that'll help us organize the conversation later.
Yes, please ask all your questions and we'll try to get through them all. If not, I can always follow up with you offline. So what happens if you don't comply with these exemption requirements? So the first one we just talked about, which is SEC registration and reporting. So not only is it a very expensive process to start, it's an expensive process to continue your annual compliance. There's also the biggest risk is actually what's called rescission. So, that's when the purchaser and anybody in the round can get their money back, sometimes plus interest. So we don't want that. We want you to be able to take in money, be confident that you can use that money and that there's not going to be a claim later on that the purchaser say, hey, I didn't have enough information to invest in this and I want my money back. From the investor side, we're going to be talking a lot about what the company should do, but for the investors with us today, these are things you can think about during due diligence. So as you're looking through what a company might have done in previous rounds, you can see if they have the documentation you would expect to see around those fundraising efforts. And if they do, you can, be more confident that the money is within the company, they're properly, there's not going to be a claim for it later. If they don't, then you have to evaluate whether that risk of potential rescission or risk of potential fines or inability to raise additional capital could be a problem that's worth evaluating further before you invest. So these are the risks that are involved. There's also monetary fines, inability to raise additional capital. There are criminal penalties that could come up. Very unlikely. We're talking Ponzi scheme type activities would be under the criminal side. And then civil lawsuits, which would be from your investors and your purchasers. So this is what we're trying to mitigate all of these risks. As we go through the different exemptions, you'll see some of them you can be much more confident that the risks are pretty low, and other ones the company needs to decide whether that's a risk they want to take on. All right, so before we get started in this, the Washington Department of Financial Institutions puts this great flow chart together, which is included in the slides. And it helps you walk through what you're doing to get you to, potentially what the correct exemption or registration process is. We're going to be talking today about the federal rules and then about Washington state. But know that each state has their own set of securities laws that apply, and they apply if your purchaser is located in that state. So it doesn't matter where your company is located. This is all based on where your purchaser is. The states have their job is to protect the people who live in their state from losing their money. And so you'll see as we go through, there's benefits to using exemptions that you don't have to think about what's going on in the states. Because there's 50 states that we have to worry about, and that can be quite a complicated process. So we're going to start with Regulation D 506B. This is, most people call this a Reg D deal. If you hear that term, they're generally talking about 506B. This is the gold standard for exemptions. So we're going to use this one to kind of talk about how other exemptions are better or worse and could apply to different situations. But the reason we love 506B is because it is you can be confident that your securities were sold correctly if you comply with the rules, and they're pretty easy to comply with. This exemption allows you to raise unlimited capital from an unlimited number of accredited investors. And in addition to just having accredited investors, you can have up to 35 non-accredited investors, but it requires a bit of extra disclosure. It also allows you to raise any type of security. Some of the exemptions on the state level could be limited to equity. There might be extra requirements if you're selling debt securities like convertible notes. So sorry, I saw Anu, a question.
Yeah, hi, a quick question. So does this apply to at the federal level, or does this change at the state level?
Oh, this is the federal level. Sorry, I realized I color-coded my slides and forgot to tell you about them. So all of the orange pieces that come up will be your federal exemptions. And then there'll be gray slides that will be all the state exemptions. So that's kind of how we're keeping them separated. But this is a federal exemption.
Thank you.
And often when you have a federal exemption, it supplants any involvement of any of the states. You don't have to talk to a state, right?
For some of them. So 506B, that's one of the great characteristics of 506B and why we like it, is because it preempts state law. You do not have to comply with the state's securities laws, but it does require a notice filing. You have to say, hey state, we sold some securities to your people, and here's what we did, and here's your filing fee. So as you can see from the slides, in Washington, it's a $300 filing fee. It's free to file at the federal level, and each state sets their own price for what they want to file. I don't think I've seen one more than like $1,000. So if you can think, you can raise an unlimited amount of capital for pretty cheap compliance fees. And all it requires is filing of Form D, which is about 4 pages of PDF fill in the blank with the SEC. You send the same form to the states with their check. So it's very easy to comply with. It's an after the sale compliance system. So you don't need to get any pre-permission to sell securities under this exemption. You can just sell them and then use them. One of the other great things about this is if you're only selling to accredited investors, you don't actually have to give them any specific disclosure. And you'll see as we go through, certain exemptions require much more robust disclosure to the investors. And so this one we like because they'll do their due diligence and you'll provide them the normal course of due diligence, but there's no document you need to write. There's no prospectus or private placement memorandum that you need to write. The only limitations to this exemption are, so no general advertising or solicitation. This is going to be a huge piece that applies to a number of exemptions. So you can't go on Facebook, tell someone you're raising money. You need to be careful with demo days and going to pitch meetings and whether that could be considered general solicitation or advertising. So it's a very fact-specific analysis. And so you'll just want to make sure you work with your legal team before you go do those things to make sure that everything's set up correctly and you can maintain this exemption, because if one part goes wrong, you can lose the exemption, then we have to look at something else that might be more complicated.
Didn't the latest set of SEC rule changes allow for solicitation, or at least looking of solicitation at demo days? Isn't that a new thing that just changed?
It did. So it's going to be updated, I believe, next month, along with a number of these other changes that are listed in red on this slide. So the SEC did just update a bunch of rules to make capital raising easier for smaller companies without needing to have a registration statement on file. Demo days are part of that, and we'll see how that shakes out. But again, you just want to make sure you're complying with those rules to preserve the exemption. So like I said, this is the gold standard. It's super easy to comply with. If you're going only to accredited investors, it's relatively cheap compared to the other exemptions and registration forms we'll see as we go through. So we love 506B. We encourage you to use 506B if you can do it, but it doesn't fit everybody's specific fundraising scenario. So I set up this presentation to go through like different scenarios. So our first use scenario is going to be, well, what happens if I don't know any accredited investors? What happens if I only can raise money from unaccredited investors? Fear not, there are certain exemptions that are available, both on the federal and the state level. So on the federal level, we start with Regulation D, Rule 504. And this allows you to have unlimited sales to non-accredited investors. You can raise up to $5 million in every 12-month period. So that's a rolling 12 months. That limit's going to increase to 10 million next month as part of the rule changes that John mentioned just a minute ago. It also just requires you to file the same Form D. So again, that's a 4-page document, very easy to comply with. But the 504 requires a state level exemption. So again, every state in which you sell securities, you're going to need to comply with their state rules. Most states have a corresponding 504 exemption because this is a pretty common one that's used. The problem is it doesn't always match up. And so we'll see for Washington's exemption here in just a minute. Washington's limit is actually $1 million for their 504 exemption. So while federally you could in theory raise 10 million, if you're offering to somebody, even one person in Washington, your limit has now plummeted to 1 million. So it's important to understand how these exemptions work together, both federally and on the state level. So in addition to 504, you also have the federal intrastate offering exemption. And so this is basically the federal government saying, hey, if you sell just within one state and your business is based in that state and all of your business is really just focused in that state, then we're going to say, let's let the state decide. The state's rules will apply. So there's no filings that you have to do on the federal level if you're relying on this exemption. You just have to make sure you're complying with the state rules. So this is kind of the federal government just backing out for a second. So let's say we're trying to raise money from non-accredited investors and we're based.
And we just switched from federal to state because you just changed to gray.
Exactly. So this is going to be our state exemption that aligns with the federal exemption Rule 504. This state exemption is the small offering exemption. It works with both Rule 504 and that intrastate offering exemption at the federal level that we just was on the previous slide. And like I mentioned, this exemption really undercuts Rule 504 because it limits the total offering, like total complete offering anywhere in the US to $1 million. And so while it's really great, you can raise up, next month you'll be able to raise 10 million of the 504. You're not going to be able to do that if you have a Washington purchaser. Now, luckily, the Division of Financial Institutions is looking at this. So they just posted a notice that they're considering rulemaking to increase this limit to match Rule 504. It's unclear whether they're going to go to 5 million or if they're going to go all the way to 10, but they've realized that they haven't kept up. Rule 504 used to be $1 million. And I think 2017, it went to 5 million. And now it's going to 10 million. So they're trying to catch up. Anu, question?
Yes, please. So is this limit per year, per offering, or lifetime?
Per year, so per 12-month period.
Okay, thanks.
And you'll, one of the things, that actually brings up a good point. So one of the things that comes up is this concept of integration. So you could raise $100,000 today, and we need to decide at what point could you raise another $100,000 in what would be considered, from the government standpoint, a separate offering. And so it used to be, well, it is until next month, that it was a 6-month look back and look forward. So any offering that looked substantially similar within 6 months of a previous offering could be considered part of the same offering, which is really hard to comply with because you have to make sure that you didn't inadvertently lose your exemption with this new filing. They're reducing that to 30 days, which we think makes a lot more sense. So you can have separate offerings that you can use different exemptions for. but total for 504 and corresponding the Washington exemption is going to be right now $1 million every 12 months.
Okay, thank you.
And in, so while 504 allows you to have unlimited non-accredited investors, the Washington exemption limits that to 20. So you can have unlimited accredited investors, all in the same offering, if you have a mix of accredited and non-accredited, but you can only have up to 20 non-accredited in Washington. As many non-Washington, non-accredited investors that you want, but that's the limit here. It requires the company to do a bit of due diligence, making sure that they believe that the investor is sophisticated enough to invest in this type of offering. And it does require some sort of disclosure. So there's no prescribed form of prospectus that you need to provide, but you do need to provide the investor something. Again, this is all based on the state's interest in protecting its investors from losing their investment. The one thing about these exemptions is when you file, when you have to ask for permission. So in the federal system, it's usually a post-offering filing. For Washington, if you need to rely on 504, you need to file a notice to the state that you're going to be doing this offering 10 days prior to the first sale. So there's a little bit of coordination and timing. This is one of the easier ones to comply with. As we get farther down this presentation, you'll see where some of those are a little bit harder. Carlos, do you have a question?
Yes. Which state would a company be under? Would it be where the company registered or where the company, fiscally resides?
So from the federal standpoint, you can rely on either, but for the most part, it's where the company principally operates. So if you're a Delaware corporation, but your headquarters is here in Washington, you do all your business in Washington, all of your officers are here in Washington, then you can say, I'm a Washington company and rely on these exemptions. It'd be harder to say you're a Delaware company to sell to Delaware investors, but it is technically possible. So they use a principal place of business test, which doesn't necessarily include where you're incorporated. It gives you a little bit of flexibility. All right, so if this exemption doesn't apply and you still want to sell to non-accredited investors, so then we're talking about how do we sell to non-accredited investors? And then in Washington, that's going to mean possibly registering your offering with the state. So the SCORE offering, which is the small company offering registration system, is technically a registration statement, but at the state level. So you're relying on a federal exemption from registration while registering in the state, which is a lot easier to comply with than registering federally. This allows you, again, up to $1 million in offers and sales in that 12-month period, unlimited accredited investors, unlimited non-accredited investors, and you can advertise. So if you were relying on 504 federally, then you could register with the state, and then you increase from the 20 non-accredited limit under the exemption to unlimited non-accredited if you register. It's not super difficult under the SCORE system, which is the SCORE form is a national form that's put out. The states have really tried to band together and say, we don't want to make this easy for people to raise capital. We want to encourage people to raise capital. So how can we make our systems similar? So the SCORE form is one of those forms that exists in many states. It's a fill in the blank form. So it's all set up for you in a Word document, questions, answers, and check boxes. So it's not burdensome, but it does take time, and you have to make sure that you're thinking through all of the questions in a very methodical way. One of the downsides to using the registration system is that it requires you to submit all of the documents to the securities division prior to any offers or sales. They get to review all your documents. They get to then say, we have questions, we want to see these changes, we think there needs to be more disclosure here. And you go back and forth until they decide you're allowed to conduct this offering. So this takes much more pre-planning, and you need to make sure you're working with your legal team to make sure that everything's lined up. The registration here also has a minimum price requirement, so you have to be selling things for at least $1 per share or per membership interest. LLCs can use this system. And then once you've done the offering, you have ongoing disclosure requirements for 5 years. So you're required to provide anybody who holds the securities that were purchased in this offering financial statements for 5 years. So that's not only do you have pre-offering requirements, there's going to be post-offering compliance requirements as well. So still not as burdensome as the federal system, but something to consider when you look at, do you really need that 21st non-accredited investor, or can we rely on the small offering exemption here? So it's really about thinking who you can make your offers to, and does that work? So the next way you could go about this is the registration by qualification system. This is also a Washington registration system. And how this differs from the one we just talked about is this allows you to raise an unlimited amount of capital up to that 504 max. So it'll be 10 million. Practically speaking, it's 10 million next month. Unlimited accredited, unlimited non-accredited. Again, you need to submit everything to the state beforehand. It's a lot more disclosure than the SCORE offering, which was the previous one we just talked about, and it's more expensive. So the founding fees can be about 10 times more than they were under the SCORE offering. But it's something that's available. Still exempt federally under 504, register with the state, you get a lot more leeway, but requires more planning. So those, all those offerings kind of work together. They use 504 federally, use all these other state ones for Washington purchasers. And again, there's other states you're going to have to comply with. It would be way too burdensome and cumbersome to talk about all the different requirements. So we're really just focusing on Washington for the purpose of this presentation. So then we have another option in Washington for we're focusing on non-accredited investor groups. And this is the intrastate crowdfunding exemption that Washington offers. So federally, you would rely on that intrastate federal exemption that says if you comply with the state rules, we're good. If you want to do this in Washington, this allows you, again, $1 million. Seems to be the limit in Washington, is everything's $1 million right now in a 12-month period. You get a limited number of non-accredited investors, so this is good. You can advertise your offering, but you need to get approval before you start your offering. So you can't make any offers, you can't really talk about the offering until the Securities Division has said, okay, you may conduct this offering. It's about 3 to 4 weeks of review. Obviously with COVID, that number can vary, pretty significantly. But just in terms of something to consider as you plan, you're about a month out. And this is after you need to complete all of the documents first, and then it's about 3 to 4 weeks of them reviewing. There's one, limitation to this that's pretty significant, and that's the actual investors are limited in how much they can invest in all offerings, not just your offering, but all offerings over 12 months. So the company is required to do a little bit of paperwork, compliance, questionnaires to make sure that the investor is saying, like, yes, my investment is not going to blow through these limits. The company is also required to make sure that you have to do a little bit of due diligence on each of your investors to make sure that they're Washington residents. So simply having your investor fill out a questionnaire that says, yes, I'm a Washington resident, that's not going to be enough for this exemption. You're going to need to look at their driver's license, utility bill, something to show, like, I believe that they're here in Washington. You're also required to use the Washington crowdfunding form. Now, this form is actually easier than the SCORE form, and Washington specifically adopted it in order for it to be completed by founders without the help of lawyers. It's really a check the box form. It's meant to be super easy, low barrier to entry, so that you can raise some money to get started without having to incur legal fees that are associated with doing larger offerings or even the SCORE offering. It does have annual disclosure requirements, so you're required to send each of your purchasers an annual report every year. So things to think about. You know, you might be able to get through this first wave of disclosure, but then are you prepared to prepare and send an annual report every year? So that's the last Washington exemption we have for non-accredited investors. Then we have one more federal. So I hope everybody is hanging in there on the all the information that's coming at you. So we're going back to federal, and this is regulation crowdfunding. So I heard a couple people during introductions talk about, you know, potentially doing a crowdfunding offering through WeFunder or Start Engine. There's lots of different platforms that are out there now. It's a great option, and it's great because you don't have to comply with state law. So this is another one where the federal exemption preempts the state law, and you only have to comply with Regulation CF. You can, right now, you can only raise $1 million. That's increasing next month to 5 million, which I think is going to open up a ton of options for small companies like we have here today, because you really get a good way to solicit investment from not just people in your state, but from all over the country. So you can have an unlimited number of non-accredited investors, unlimited accredited investors. You do have those ongoing disclosure requirements, so same as previous exemptions we just talked about. You'll have to make sure you're prepared to send annual reports every year about the health of your company. And there's a bit of disclosure that's required. So in order to get the benefit of these platforms, you have to use Form C, which is the SEC form. It's pretty extensive disclosure. Again, not as much as, you know, might happen at the federal level with a full-blown registration, but still something to make sure you've looked at prior to embarking on a crowdfunding offering. And it does require you to have financial statements. So those need to be potentially reviewed by a CPA. They don't need to be completely audited, but they do need to have someone outside the company take a look at them. And you need to use an actual registered portal. So again, WeFunder, Start Engine, those types of things. So before we move on to the next topic, any questions about non-accredited investors, the exemptions that we've talked about? Again, I'm not sure I can see the chat.
So can you talk through what accredited means in some level of detail? And specifically, let me give you a hypothetical edge case. Let's pick on, let's see, Jeff Collier. Jeff Collier has this great idea. He goes out and he, you know, is him and his partner and his dog with an idea. He goes and finds somebody and he takes $100,000 from his uncle at a you know, $2.5 million valuation. He has no money other than the fact that he has this company. Now on a piece of paper at a priced round, he now has $1 million worth of equity in this startup that he just got. Is he accredited?
For the purposes of his own company, yes. For the purposes of other companies.
No. I understand he has a company that's been priced and he owns share in that company that's been priced and its assets.
You know, that's a good question. I am not recalling off the top of my head if you can include those securities in terms of, because you're so associated with the company and because they're not free trading securities that are available to on a public market.
Yeah.
Being accredited.
So I'm pressing on that one for a reason, because when people say that, you know, in an accredited investor, I have to be a millionaire, not counting my house. And they say any assets. And so then there are cases about, you know, if I own $1 million car, is that an asset, right? There's a whole bunch of questions about what do we mean by asset? And also when we talk about income, what do we mean by income? Can you dive into those little distinctions a little bit?
Sure. So for the income test, and I don't have in front of me, it's $200,000 for the last year, and an expected that you're expected to continue that salary for the next 2 years. That's for an individual. It's $300,000 for a couple that files their tax returns jointly. And so if you meet those income requirements, even if you don't have the $1 million in assets, you can still be considered an accredited investor for that year. And then each year you have to make sure you're meeting those requirements again. And
so Alex just asked in the chat, do crypto assets count?
It's a great question. It's going to depend on whether they're publicly traded. So is it a liquid asset that
you're using a market test for assets?
You need to be able to have a liquid asset. So something that's not
where
liquid.
Does liquid come into the conversation? That's not what the rule says.
So that might just be a practice pointer that I've picked up over the course of doing this. But I can follow up with you on that one, on where it came from to me.
The reason that I ask is that frequently there are money managers who won't talk to people about managing their money unless they have, you know, $2 million in liquid assets. And somehow that magic number ends up getting covered over everything else, right? And so then people start saying you're accredited if you have liquid assets of blah. And so I'm trying to find where the edge of that is. So now we have Jeff, and Jeff has this asset, which is his business, which he can sell to someone else in the same way. But you're saying it's not publicly tradable, therefore it's not a liquid. And so we need to find out where the edge of that line is. But if Jeff went public and did a DPO, and that was something that could be purchased by anyone, then it would be a liquid asset that he could sell freely. And then he would be a millionaire at that point because he had shares of stock that were on a public trading platform. Yes?
Right. And to your point, it might be that this is something I've picked up in practice, that the attorneys I've worked with are more conservative in advising their clients and making sure that this is the best case scenario, that you can show liquidity. But I am happy to follow up with a nice slide supplement here on what the accredited investor rules are. There were some new categories added last year, middle of last year, that allow for certain people who have financial licenses to be accredited, even if they don't meet the income test or the asset test, because the SEC feels that they can evaluate the risk properly. So there's a whole bunch of different categories of accredited investors, and I'll add a slide and we can get that sent out too.
Okay, thank you. I want to distinguish, at the moment, there's no education requirements that make you accredited. You don't take a course and then get a certificate and then put you are accredited. And when on March 15th, if you have taken one of the FINRA exams, then you can qualify as being accredited under the new rule changes, right? That's a brand new shift. Right?
Correct. So there's no public test that I could just go take and say, now I'm accredited. It's about you have to have a license in a certain field.
Right. Thank you.
Limited to financial.
There is some conversation about angel groups being able to run workshops that turn into certifications, but that's not been approved by the SEC in practice yet.
And that would be a great addition. You're right. It's not something that exists today, but I think being able to open this up to people who can evaluate risk would be amazing for the industry and amazing for capital raising. When you think about, you take a step back from all of this information that we just went over, the purpose of these regulations are to protect the investor. So are you sophisticated enough to know I could easily lose my money if I invest in this? I understand there's a really good chance I'm not going to get my money back. And I think everyone should be able to make that decision, even if you don't meet certain income requirements or asset requirements. You should be able to say, I can lose my $50 if I participate in this crowdfunding. I'm okay with that. And so the more we can open it up, I think the better. We're just slowly making our progress there.
Right, makes perfect sense. Okay, so now I have this crowdfunding thing at the federal level, and you were in the middle of that conversation. And can you talk a little bit about the platform requirement? I don't see that on the list.
So you have to make the offering through an SEC registered platform or a registered broker dealer who's set up to do crowdfunding. So generally we focus on the funding portal, and so that's under the compliance piece on the slide. Those portals have their own rules, so they need to comply with the base minimum of what regulation crowdfunding requires in terms of disclosure, looking at who the investors are, making sure the investors are meeting, not exceeding their limitations. But beware that some portals limit crowdfunding to only accredited investors. So it'll be important from the company standpoint to look at which portal you pick and say, okay, this one allows me to access the non-accredited investors because that's what I want to do for this offering. If I want accredited investors, I can go a different route.
So some of the portals like WeFunder provide the opportunity to have raising money from unaccredited people in one offering and raising money from accredited people under like a Reg D 506C, where I can do general solicitation for accredited people for that offering, and they manage both of those things at the same time. So running two offerings at the same time is possible. Is that correct?
It depends on what you're selling. So if you're selling the same security for the same share of preferred stock and at the same price with the same liquidation preferences, there's a good chance that those offerings will be considered integrated for the purposes of federal securities laws, and you could lose your exemption that allows you to sell to non-accredited investors. So if they're different offerings, though, that is possible.
So if I want to raise, you know, my $1 million and I'm raising it $100 at a time, and I get thousands and thousands of people and I sell them a piece of equity, does that trip me up?
Are we still talking about having two separate offerings running at the same time?
Well, I'm going to walk back into that. And so, I mean, why would I want to do that? So I sell this, and there's a limit to the number of bodies I can have, right? The number of shares I can sell to different people is limited at some point, right?
So you're only limited in the total dollar amount that you collect total for the offering. You put up,
well, except that I don't really, I mean, the reason that I'm doing an exemption is so that I don't do all of the registration costs, right? Because the classic answer is I just register and I go off to where I'm going and I'm done, but that costs me hundreds, if not millions, hundreds of thousands, if not millions of dollars. So if I want to avoid registration, then I can only sell so many. And you just said the number. What is the number?
So it's 2,000. Sorry, now I see where you're going with this. So yes, so that's an important point, and thanks, John, for bringing it up. If no matter what you do, if you comply with all of these exemptions and each of your funding rounds, you know, complies properly, but you end up with more than 2,000 investors, you automatically have to register as an SEC reporting company. And so you want to make sure that you stay under that limit. So you're right, these unlimited number of non-accredited investors is backstopped by that 2,000 in total investor limit.
And usually when I sell a stock, I'm selling rights with that stock, like the ability to get information or not, or the ability to vote on specific things, or the ability to sell it to other people or prevent the sale of things by founders and so forth. So could one of the ways that I run these two things separately, because it would be a significant pain in the tuchus if I went and had to get a signature from 2,000 people in order to complete a deal somewhere. And so I might make a shift to the deal terms to the crowdfunding where I don't allow them to vote about anything and I don't particularly give them information rights. So I might actually sell two classes of stock. Is that correct?
Yep. So that would be how you could run two offerings at the same time while avoiding those integration issues. You could sell to non-accredited investors non-voting shares, and you could sell accredited investors under 506, you know, preferred shares or what other class of shares you want.
And so can you dive in a little bit about the notion of the cap table and how all of these regulations impact cap tables?
I mean, so every time you offer more securities, we're all familiar with the concept of dilution. So your current investors might not like continual offerings that are made to, you know, up to $5 million, up to $10 million. So that's one part, is just diluting the value of your prior shareholders' investment in the company. The second is what we just talked about, and that's making sure you're keeping an eye on your cap table to avoid inadvertent SEC registration. That's a scenario you don't want to have happen. Now, some of these exemptions also come into play if you want to offer your shareholders the ability to sell their shares as a secondary offering. Most of these shares are all restricted securities. You're not going to be able to resell them except pursuant to a registration statement or an exemption. So I didn't include any of that in this presentation, just given trying to narrow our scope. But that's one way you could do it if you're coming up on that 2,000 person limit, is saying like, hey, shareholders, we want to offer you a liquidity event and try to sell 1,000 shareholders shares to 100 shareholders. Now you've reduced your number of shareholders.
So I see a question in the chat by Shilpa around, is crowdfunding perceived by institutional investors in the market in terms of attractiveness and startup of subsequent rounds? So does the use of crowdfunding or does the use of any particular mechanism improve or reduce the ability to do the next round as I move from, you know, unaccredited to accredited to institutional investors?
You know, it's a great question. I don't know the answer to it. I do know that complying with Rule 506B is the easiest one to diligence, because you know exactly what should have been provided to accredited investors. You know exactly what documents should have been filed and by what date they need to be filed. But in terms of the rest of these exemptions, the more complex the exemption or registration, as we saw for Washington, the more from the investor side you need to diligence to make sure everything was done correctly. And so just based on that, you know, 506B again is the gold standard for being able to show easy compliance. 506C as well, if you can meet the, we'll talk about that here in just a minute. But John, you might have more insight on that than I do. I'm mostly on the company side.
So I would say that yes, if you're doing crowdfunding and you're collecting a whole bunch of people on your cap table and you haven't done that in an obviously clean way, you can completely stop the opportunity for an institutional investor to come in, right? And so having things be fuzzy around the edges is a great way to get to know with the institutional investors. On the other hand, having crowdsourcing, which is you sold product, not shares in the company, is a great way to demonstrate market demand and community interest. And so understand why you would sell product versus why you would sell loans versus why you would sell equity. There are a bunch of choices that you can do in there, and they each have consequences. Some are advantageous and move you forward, and others sort of close doors for you. And so if you think about a seed round, in a normal angel funded seed round, the companies that were funded, 66% of them do not receive a Series A round. And so there's already a constriction in that process of selecting the right good companies that will become billion-dollar companies. And that's what the institutional investors are looking for. And part of the reason that we're going through all these different exemptions is that there are other options besides venture capital for raising money that are past your seed round. You can do rounds now of $10 million here soon, of getting a reasonable Series A level of investment from a different group of people than institutional money. And so when you plant the flag at your pre-seed with how I'm doing it, and you go to your seed and you go to your Series A and you walk through that series, you're building a capital stack, and they need to be compatible with each other. And Tyler is saying crowdsourcing, selling product doesn't interfere. Not usually. The selling a product has no constraints on what the value of the company stock is, essentially, right? And that's what we're trying to manage, is the ease of how you engage with the ownership of stock in the company or the ownership of debt obligations to the company, because companies like Lighter Capital sell revenue loans to startups, which are also a regulated activity.
Right, and it's important. So two things in there. One, if you're selling debt, you need to be able to service that debt. So you can't make your company insolvent by over leveraging. And two, Tyler, to your point, you're correct. So if you're selling product or just taking donations through a GoFundMe, those are not implicated. The securities laws are not implicated there. So we are only talking about crowdfunding in terms of selling equity or something that could be convertible into equity. So stocks, convertible notes, safes, things like that.
So can you talk a little bit about if I wanted to make an offer of I'm going to sell you a slice of a loan, which is a revenue loan, right? No equity. I'm 100% on the debt side, but I will pay 4% of my revenue over the next 10 years. And you can get a slice of that if you buy a slice of this loan. Where is that regulated?
So the person holding the note is selling part of the note?
No, the company is selling the note to 100 people and you're buying slices of the note.
So if it's just debt, then it's not covered under the securities laws. If there's no chance of you getting
what is it
equity,
covered under?
There's other financial regulations that cover loans and debt and promissory notes generally. I don't know all the ins and outs of that piece.
Okay.
But it is you want to make sure you're doing it correctly. There's certain minimums that have to be met. But in terms of it's just straight debt and it's just you're getting paid back with interest, and that payment schedule is based on revenue, then you're not within the securities laws that we're talking about here. So so this is everything that we're going to talk about in terms of you looking at primarily unaccredited investors. The next use case we're going to talk about is, well, what happens if I need to advertise? So you don't know any accredited investors, you want to get the word out. We're talking general solicitation, so putting out a press release that includes pricing information, posting something on social media or other publicly available message boards about your fundraising efforts, all are considered general solicitation and advertising. And if you don't comply with the rules that allow you to use general solicitation, you can blow your exemption, and then you could be required to register, or you've now sold an unregistered security and you could have problems down the line. That's where those risks came in. So the big one for the federal exemption is going to be Rule 506C. So 506B is no solicitation to accredited investors. 506C allows very similar, so unlimited amount of capital, unlimited number of accredited investors, and you can generally advertise. The kicker is that there's no non-accredited investors, so only accredited at this point. It is an exemption that preempts state law, so this is one where you only have to comply with the federal rules, and then you just supply the same SEC Form D to your state with a check to tell them, hey, we sold securities in your state. There's no prescribed disclosure required, so this is another benefit to using 506C to accredited investors, because you need to provide them, again, the due diligence that they request, general information about your company. You need to make sure you're not misstating or overstating the value of your company, but otherwise, no prescribed disclosure document. So you might be thinking, well, why don't we just use this one all the time? Because you get all the benefits of 506B, but you also get to advertise. There is one big difference between these that gives you the permission to advertise. So under 506B, you only had to have a reasonable belief that the investor was accredited. And the SEC has said that a reasonable belief includes having the accredited investor fill out a questionnaire. So you have all the listed categories of accredited investor, sign, I'm this type, give it to the company, and the company says, okay, well, this investor is accredited, they told me so. With 506C, in order to get the benefit of having general solicitation, the company is required to actually vet and verify the accredited investor status that the investor says they have. So if you say, I'm accredited because I make more than $200,000 a year, then the company is required to verify that through, reviewing the W-2s, reviewing of employment agreements. There's a level of disclosure from the investor side that not all investors might be keen on providing. There are services that offer these verification services, and so the company itself is not doing it, but the company is required to pay for this service, and it can get quite expensive depending on what you're doing. Also, like I said, a lot of investors might not want to make that disclosure. So this is one of those cases where it was really important to think about what, as a company, what exemption are you going to want to rely on, and telling the investor early, hey, we want to rely on 506C. That's going to require you to provide us with the information we need to meet our obligations. That investor might say, thanks, but no thanks. I don't send, my portfolio to anybody, and I'm going to pass this round. Let me know when you do a 506B offering where I can just sign a form. There are some new rules coming out that make this verification process easier. It allows you to rely on a 5-year look back if you've previously verified an investor. Those rules go into effect next month as well. And so one of the issues with 506C is because it allows public solicitation and the general advertising, if you mess up the exemption, there's no other exemption to rely on federally. So this is one where if you want to go down this route, pre-planning is going to be key, and you really want to make sure that the benefit of that general solicitation is worth it, because otherwise you needed to get approval before you sold the securities, or you needed to fill out the extensive disclosure forms and use the funding portal like under the crowdfunding model. So it's huge benefit, unlimited number of capital, unlimited number of accredited investors, but the compliance part is going to be key. You want to make sure that you are ready to take that on. So that's public solicitation on the federal level. The next couple of slides, so we've already talked about 504. This does allow some public solicitation, but it's in compliance with state law, and a lot of times that needs to be pre-approved. So again, going back to that pre-approval characteristic. The SCORE offering in Washington also allows general solicitation with pre-approval of the solicitation and of the offering. And the registration by qualifications the same way. So you have to pre-approve of the offering, pre-approve of the solicitation you're going to do, but these are available to you if you want to raise money from accredited investors and advertise. Washington has one more exemption, which is the model accredited investor exemption. This, you have to be relying on Federal Rule 504. So that's the $5 million, soon to be $10 million exemption. In Washington, you'd be capped at $5 million, but you can sell to an unlimited number of accredited investors. So we had talked about the small offering exemption in Washington, which was capped at $1 million, but allowed non-accredited. If you take out the non-accredited, you can go up to $5 million and you just use accredited investors. Pretty easy to comply with, pretty simple forms to fill out, including just the request for the exemption form and the Form D that you fill out. Those are what's available if you want to advertise. It's pretty limited. Again, thinking about the policy behind it, we want to protect investors. We don't want to just go out saying I'm raising a whole bunch of money and not give people the disclosure that they need to make that investment decision. So then, any questions about public solicitation?
Yeah, could you go through, you know, if we find that lawyers are conservative, and sometimes when we have them announce, companies announce that they are participating in the Seattle Angel Conference, some lawyers will say, you cannot announce that you're participating because that's a solicitation. So can you help us understand where are the lines in a reasonably bright way of what solicitation means when I'm in a public meeting or I'm in a public media and I say, I am doing X, like I am fundraising, is that a solicitation?
So you're right. So different lawyers take different approaches to this. There's unfortunately not a bright line that we can draw because the SEC doesn't give it to us. It's all based on facts and circumstances surrounding that particular offering. In my opinion, saying you're part of the Seattle Angel Conference, period, I don't think would be enough because you're not. The things that we look for are how much are you selling? What's the offering price? What's your maximum that you're trying to raise? And any other specifics about that particular sale, so that particular offer. And pricing is really important. In the public markets, there's limits on being able to say whether you're underwritten or not. And so you'll see this come up if you're following the public markets. There's a lot of information unavailable about who's underwriting a deal when it is announced. In terms of having a presentation, there's some debate on how much you can say. So I'm raising my Series A round, period. Well, maybe that's not enough. And if you're giving a slide presentation, we can put in disclosure that says, nothing in here is considered an offer or sale. So lawyers like to paper over a lot of things, and that's one way to do it, is to have disclaimers that say nothing in here is to be considered an offer or sale. We're not selling securities. This is simply just information about the company. But if you're doing that and you have some other, questionable disclosure announcement that came out, those together could be considered general solicitation. So it really depends on looking at the whole situation. I know that's like the worst answer you can give is it depends, but unfortunately that's where we're at.
The lawyer's favorite answer, it depends.
It depends. We teach them in law school.
Can you dive a little bit into what it means to be a bad actor and what, why a founder would never, ever want to be a bad actor?
Oh, sure. Yes. So these have been listed under the limitations in a number of the slides. So a bad actor is, it's a very complex definition, but in essence, like you've done something wrong related to the buying or selling of securities. And so bad actor disqualification can limit if somebody is part of your company, so an officer, a director, or a 10% or more shareholder is a bad actor, then your company cannot rely on any of the exemptions that I've listed bad actor disqualification, which is most of them. So Rule 506B, C, in front of us, the model accredited investor exemption, you're not going to be able to rely on those. So then you're stuck in needing to have a registered offering or use some other type of exemption. And there's a couple more that we'll talk about. This is really important for when you're bringing on shareholders. So you generally will know, your officers and your directors, whether they are bad actors. But maybe you have somebody who's come on your cap table at 5%. And they start creeping up, and you've never had to ask them about their bad actor disqualification because they weren't at that 10% threshold when they first invested. But now they've suddenly reached 10%, 20%, giving you a huge infusion of cash, and you didn't disclose that they were a bad actor. Well, that can really complicate future fundraising efforts. So we always encourage every company to have a bad actor questionnaire for every investor that invests, no matter at what level, and it just gets them to attest to none of these bad actor disqualifications apply. And then anytime there's an offering, you go back prior to making the offering and ask your officers, directors, and anyone who is at 10%, please confirm that these are still correct so that we can do our offering correctly. A great point, John. Thanks for bringing that up.
Any other questions from anyone?
Okay, if not, then we're going to go. Oh, Anu? Yep.
I have a amazingly stupid question, but this, whatever we discussed today, is essentially for individual investors and not venture capitalists.
No, they still apply to venture capitalists.
It does. So, like, for example, if a VC firm decides to fund my startup, is that funding considered as a single instance, or like maybe this is I guess some of the limits that you mentioned earlier about the number of investors were only for non-aggregated investors. So I guess thanks.
Can you talk a little bit about deal structure and what a round looks like? Because we threw out, pre-seed, seed, and Series A as rounds. And I think what he's asking is, in a round, how many people do I have in a round, and how do rounds and investments and checks from people connect to SEC exemptions?
Yes, thank you.
So how you're going to count people is going to be based on what name goes on your cap table. So if you have a VC fund that just says, we're ABC Fund LLC, then that's one shareholder. And that fund can be itself accredited. There are entity level accredited investor status. And again, I'll supplement the information here with a list so you have it. If the fund says we want to invest, but we want to split this up over 5 different funds, then that would be 5 different investors from technical standpoint. And each of those 5 funds would need to make sure they meet the accredited investor status and the bad actor disqualification, that none of those apply. So when you structure a round, you want to talk to your investors early and see, are they going to be investing through one fund, through multiple funds? I've worked on deals where it's suddenly you get to closing and they're like, oh, actually, can you break this out onto 3 different funds? We want to split it up, and here's how we want to allocate it. And we have to make sure, yes, that we're from the company's exemption standpoint. But you want to make sure the investor's already there, ready with their 3 checks, and you would hate for there to be a problem because that one person put you over some limit.
Thank you.
And so a round involves the collection of all people who take money in a specific time frame into a single offer.
Yep.
Yep. And so I might take 50 checks. I may take one check, and it could be from individuals and it can be from institutions or organizations. So organizations become accredited when they have $5 million in assets, or their members are all accredited. And so by default, the organization is accredited. And that organization can be a for-profit fund, or it can be a nonprofit with assets above 5 million and still be accredited.
Right. And that's a great point, John, in terms of figuring out when your round ends, because you could do, say you did your Series A round, you had 10 investors, they came in, and then you closed it, you sold all the money you were gonna, all the shares and met your funding goals. And then 25 days later, somebody heard about your company and wanted to also invest. They know you don't have an open round, but it's a good investment, seems like a good partner to your company, you want to bring them on. Under the integration rules that I know we only briefly touched on them, that new person at 25 days post closing could be considered integrated into your offering. So you want to make sure that that new person doesn't spoil the exemption that you were relying on in your round. And that, like I said, that look back used to be 6 months, or still is today, but next month it'll be 30 days, which makes it a lot easier to just be like, well, let's just wait, another 6 weeks and then we'll take your investment, because we need to make sure that the exemptions are still holding solid. So it's an important thing to keep in mind when you're looking at when you're taking in money and how additional money can impact previous rounds.
So what behavior, process, habit does a startup need to do so that they keep their exemptions clean? What are they recording where?
So we always run sort of a shadow cap table. So you have your main cap table, that's the official one that you can send out if anyone needs to look at it. And then you have your second one that lists how the investor came in, what round, when they closed, do you have an accredited investor certificate from that investor? Do you have a bad actor certificate from that investor? So that you can look back and say, okay, if we bring on this new person, how does that interact with what we've recently done? And that's what we recommend doing is really it's about data management so that the information is quickly accessible. You don't need an attorney to do it. We encourage everyone to have a legal team when you're working on raising funds at all, but we realize that that's not always possible. So keeping some sort of shadow cap table where you can look at the investors that are in and how they came in will be important. And your new investors are going to see all that in due diligence anyway. So if you can provide them a spreadsheet that says, here is everything you need to know, go see file 1.1 in our data room, you are going to make the next investor super happy and reduce your legal fees because there's going to be a lot less digging around by the legal team who's doing the diligence for the investor.
And we will talk in excruciating detail about data rooms next Tuesday night in the preparing for due diligence talk on Tuesday night. So you can find that in our meetup group.
I want to make sure I'm there. I've looked at my fair share of data rooms as someone who's helped companies go through these rounds and also done the due diligence for public offerings, which is a lot more complicated. So kind of transitioning into a quasi-public offering, what happens when your company wants to raise more than 10 million? So we're saying 10 million because that's going to be the new 504 limit in a month or so. So more than 10 million, you are right on the cusp of needing to get registered with the SEC and go through the entire public offering process. There is one way that you don't necessarily have to go through that, and that's through Regulation A. So you might hear Regulation A, Regulation A+. This is all the same. Within Regulation A, there's 2 tiers. We have Tier 1 and Tier 2. They're different offerings. They have different characteristics. But the important piece of this is this allows the company to sell the securities directly. And so in a public offering, so if you do an IPO, it's an underwritten deal. So you have an investment bank who buys your shares and then resells those shares as a broker to the public and people they have lined up to buy the shares. That's a very expensive process. Doing an IPO, you have your lawyers, you pay for the investment bank's lawyers, everyone wants to say and how it goes. That's how it gets so expensive. But a Regulation A offering allows you to access the public markets yourself and keep an offering open for an extended period of time to try to raise the capital that you're looking for. So above 10 million, we're going to be in the Regulation A sphere. So Tier 1 allows you to raise up to 20 million, unlimited number of accredited investors, unlimited number of non-accredited investors, and there's no limit on what each non-accredited investor can invest. So if they want to put their life savings behind this, that's up to them. You can solicit, you can advertise. There's new rules about testing the waters and demo days, which we were talking about earlier with some of the rule changes. You're still subject to the bad actor disqualifications that we just talked about, but that's really like what a Regulation A offering looks like. Now the catch is you have to have effectively a prospectus. So Form 1A, I'm realizing there's a typo on my slide, but Form 1A is a mini prospectus. The instructions and form for Form 1A are 30 pages long. So that does not include the information that you put into it, like the check the box forms that Washington has. That's just the instructions. And so it's a complicated process. It's a more expensive process, but you're raising $20 million. So you might be able to afford to spend the, hundreds of thousands of dollars on legal fees to get this process started. You 100% need to work with a qualified attorney if you're doing a Reg A offering to make sure it's done correctly. And also because your prospectus is subject to SEC review and comment. So you have to send it to the SEC beforehand, tell them you're going to do an offering, and they're going to review it and make sure that it complies. So with the Tier 1, so up to 20 million, the SEC process, you also are required to comply with the state blue sky rules, the state securities laws. So there's another level of compliance there. So in Washington, we have the registration by coordination. So these are registered offerings. These are not exemptions, but they're like mini IPOs. So we're covering them because they're still within the realm of what a emerging company could do before it becomes a full-blown public company. So this registration by coordination system actually allowed you to use the same Form 1A across multiple states, and only one state takes the lead on reviewing. And if the state signs off on it, after the SEC signs off on it, then you're fine. But you'll want to make sure that you're looking at, do all the states that you're selling participate? Who do I need to send it to? Are there any other fees that need to be filed? So in Washington, that fee could be up to $5,000. That's in addition to, the legal fees and accounting fees that you have to pay to get ready for this type of offering. So Tier 1 is still, accessible. You don't become an SEC reporting company. There are ongoing disclosure requirements in terms of financial statements and annual reports that need to be sent to the people that invest in your offering. But it's doable. It's still, we're talking bigger growth company, but still within the realm of doing. Once you pass 20 million and you want to raise more than 20 million, then we go to Regulation A Tier 2. So Tier 2 allows up to 75 million. That's going to be the new limit here in March. And same form, so Form 1A, but you become a SEC reporting company. So you end up having to file all of your reports on EDGAR, which is the SEC disclosure system. you need audited financial statements, but you can't have any, sorry, you can have non-accredited investors, but you can't, they're limited in what they can invest in a tier 2 offering. The benefit of doing a tier 2 offering over a tier 1 offering is that you're not subject to the state compliance rules. So this is another one where the federal law preempts state law. You're just required to comply with the federal rules. And in both of these scenarios, for tier 1 and tier 2, your investors get free trading securities. So they can sell them on the OTC. They're not subject to resale restrictions. And that's really attractive for a almost IPO ready company, because you can really show that we're ready to go. We can meet this disclosure requirement, and people are interested in our securities because they're selling them on that secondary market. So this is, way down the line, I think, for where we're at in terms of the companies that participate on it in, angel conference level. But it's important to think about the steps and how you go and what comes next. If you've maxed out on 504 at 10 million, well, now we really need to be talking about doing a Reg A offering and making sure we're prepared for that.
So might I use a Reg A offering in lieu of a Series A institutional round?
Good, if you're prepared to do the the compliance requirements. You're just putting it out there for the public to buy from you. It's a bigger climb, because if you're doing a Series A, you're still trying to build momentum behind your company. This is maybe better suited for in lieu of even a B or a C round. It just depends on what kind of funding you need. If you need the money and that capital is important to you, then it's within the realm of possibility.
Cool.
So those are our main exemptions for these funding rounds. So you're needing capital. What do we do? What I wanted to, just for the sake of completeness, and so that some things to keep an eye out for, there's a couple other exemptions I wanted to cover with you. So what about stock options? What about equity compensation? Do these need to comply? And the answer is yes. So federally, your stock option plan needs to comply with Rule 701. That's the federal law. And then also needs to comply with state law. It's not a complicated process. It's just making sure that your stock option plan that you adopt meets certain requirements. And that's it. There's not much else to it. There's no filings that need to be made. You just need to comply with the rules. So when you're writing a stock option plan, just something to make sure you've checked off as complete. In Washington, so most states have what's called a self-executing exemption. If your stock option plan meets the rules of 701, then the state says, great, we're good with that. No need to file. You just automatically are complying with our laws. Washington does not have that. So unless your plan meets certain IRS rules, which are listed down here under compliance, if it doesn't meet those rules, which it isn't required to, then you just need to file the plan with the state of Washington 30 days before you issue any stock options. So this is, again, just one of those, it's a calendar issue. It's saying, okay, we want to do this. Do we have to comply with any specific rules? And, are those complete before we do so? If you have employees in multiple states, or you have directors or consultants you want to offer stock options to in multiple states, you'll need to make sure that where that person lives, are there any requirements? It's easy to comply with. I think it's a $50 filing fee. You send the plan in, and that's it. But just something that needs to be done. So what happens if everything we've talked about today doesn't apply? Something has gone wrong. You didn't talk to your legal team. You didn't attend this workshop and know what you were supposed to do to raise funding or to issue a stock option. Like, is the world coming to an end? It is not. We have what is the biggest catch-all exemption federally, which is a 4A2 exemption, and that's just how it's referred to in the capital markets world. And 4A2 just says it's a transaction not involving a public offering. That is the full text of 4A2. But what does that mean? Like, what does not a public offering mean? They've provided, the SEC has provided some, factors to look into. This is the facts and circumstances test. So as we've talked about this whole time, a lot of this depends on what's going on with your offering. What are you selling? Who's buying? What information did you provide them? 4A2 requires a state level exemption. Washington has an equivalent 4A2 exemption. So if you meet the federal 4A2, then the state says, okay, we're good with that. The problem is there's no, unlike 506B, all of these exemptions we talked about has very clear bumpers on if you do this, then you complied. 4A2 is up for interpretation. It adds a level of risk for the company to rely on. You need to have, a very clear argument that this was not a public offering. So say you're early, very early, you want to sell 10% of your company to your parents. Well, your parents probably know everything about your company because you've been telling them about it. And, they have the money to lose. This isn't like they're putting up their house. Probably we could put it into 4A2. That would probably be fine. But we don't want to rely on this all the time. This is really like, is there a one-off case that doesn't comply with everything else, or we can't quite fit it in, but we think, this investor is sophisticated, knows exactly what they're doing, then we would rely on 4A2. So there's some wiggle room, but again, it comes with a significant amount of risk to the company. So this is Washington's equivalent 4A2 exemption. And then Washington adds another layer, which is effectively your first 3 4A2 sales every 2 years, we're not going to question. So Washington allows you to sell 3 times every 2 years, accredited or non-accredited, to a non-accredited investor. And they're just not going to say anything. They're just going to say, okay, you get those 3 sales, but that's it. And after that, then we'll look at whether section 4A2, those rules apply. So a little bit of breathing room if you're worried that you've done something wrong. We have 3 that we can get to, that we get to use. So after all of that, here are what we want to take away from this whole presentation. Before you start fundraising, here are the items that you need to consider. Talk to your legal team before you start selling things, before you start giving away stock options. Get them in the loop of what's going on. It does not need to be, a huge billable conversation. Involving attorneys early is generally cheaper than involving them after the fact. It's just the way it is, so that we can start learning about the company, knowing what you're doing, and prevent problems before they happen. Remember, offering the security and not just selling the security triggers securities laws. So just because you're telling people you're selling, shares at $1, well, now you've triggered compliance requirements. So be careful about what you say to whom, and then know your partners so that those disqualification rules come into play. And then you need to hold me. My information will be in the slides that we send around, but that is